My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the incredible Rebecca Hicks, a Texas construction lien law expert. Today's webinar topic is Texas lien waivers, best practices, and the gotchas to look for. So without further ado, I'd like to introduce the fabulous and wonderful Rebecca Hicks.
Good morning, everybody. I'm glad y'all could all be here. This is one of my favorite subject matters because I think there's a lot of confusion about what to do with these lien waivers. So that's what we're going to hope to clear up today. As she said, my name is Rebecca Hicks. I'm board certified in construction law and have been practicing in construction law for over 25 years now. So as we go through the presentation, if you have questions, please feel free to ask. You don't have to wait till the end. If you have a question about what I'm talking about, throw it in there so that we can talk about it. So this is what we're going to talk about. Today we're going to be just covering the basics of lien waivers, right? We're going to be, so you're not going to know every nuance of every little detail about everything about construction law or mechanics lien law or bond claims, that kind of thing. We're purely focused today on these lien releases, these forms that folks are asking you to sign in exchange for payment. That's what we're talking about. So hold on just one moment. So what is a lien? Just basically, what am I talking about? What is a lien waiver? It's just a representation by you that says that you've been paid for the labor or the materials that you did, that you supplied, and you will be paid out of the next draw. That's what it is. And depending on whether you have been paid or are waiting for payment, is dependent on whether you sign a conditional form of lien waiver or an unconditional form of lien waiver. And we're going to talk a lot about that in a few minutes. So don't stress there if you don't know what I mean by that. In Texas, I think about 6 years ago now, maybe closer to 8, our legislature realized that there was a big problem with these lien waivers and all of the confusion in the construction industry about them. For the most part, what was happening is general contractors were putting all kinds of crazy language into what they call just a standard lien waiver, and then they were making subcontractors or suppliers sign them before they would pay them, and it just basically wasn't unfair. It was unfair. And so the Texas legislature said, we're going to step in and solve this problem. So what they did is passed a statute. There are 4 statutory form lien waivers in Texas. Now, what I've got on the screen, those are the 4 forms. If you do not have a copy of the statutory forms, and they are word-for-word forms, just right at the legislature said, we're just going to solve this problem. We're going to tell you exactly what the form needs to look like, and here's 4 of them, and that's what they did. So if you are using something that is older, that is not these statutory forms, my advice to you right now is to just throw it out. Don't use it anymore. And get you some copies of these statutory forms. If you send me an email, I'll be happy to have my paralegal send you over a copy of the statutory forms, because all it will be is seriously word for word what's from the statute. That's what it is. So the 4 forms that the Texas legislature says we need to be using now is a conditional waiver and release on progress payments, unconditional waiver and release on progress payment, conditional waiver and release on final payment, and unconditional waiver and release on final payment. And we're going to go through each of these and when you need to be using each of the forms. Okay? So what should these forms be used for? Now, technically, these statutory forms that we're talking about only apply to private projects. So that means if you're doing work on a state or local government job, say a school, with an ISD in it, so an independent school district, you're doing work. Technically speaking, do these forms apply? Nah. If you're working on a federal job, would these forms apply? Nah. Also, there's a big carve out that after you filed a lien, if you went ahead and filed your lien of record, then these waivers are not mandatory anymore. These forms are not mandatory anymore. But what my advice, my practical advice to you is, just because it no longer is it's not mandatory to use these forms on a public job, or it's not mandatory to use these forms after a mechanics lien's been filed, use them anyways. Why? Because they're fair forms. They're fair to all parties in the construction chain. It's hard for folks to argue about the format of the lien waiver if it's right from the statute and the legislature said this is what it needs to say. So, big picture, if you can use these forms for any circumstance and you don't have a GC squawking about it, go for it. That's what I think you should do. That's just the most practical and easiest way to go about it. So, conditional versus unconditional. I told you we were going to talk about, though. What's the big deal? The big deal is a check is not payment. So if you want to use a conditional form anytime that the money is not already in your bank account. A check does not mean the money is in your bank account. A check means that you got to deposit the check at your bank. Sometimes they can be returned for insufficient funds up to about 2 weeks. And so what are you going to do? You are not going to sign an unconditional form of waiver in exchange for a check. And actually, when you look at the Texas forms that we're going to go through, there's some language in the statutory form right at the top that on the unconditional form, both of the unconditional forms, remember, one's for progress payment, one's for final payment. On the conditional form, there's language right at the top that says, do not sign this in exchange for a check. The reason for that is because a check is not payment. So what happens if you sign the unconditional form in exchange for a check? Quite frankly, we don't know yet. It hasn't been litigated yet. So could it mean that you waived your rights, your lien rights? Because if the check bounces, you sign the unconditional form in exchange for a check, then the check bounces. Do you still have lien rights or not? Nobody's litigated that. But given the very clear language at the top of the form, it's going to be an uphill battle, I think. But we don't have a case law on it yet, is the short answer. But in short, just don't do it. And I still see general contractors misunderstanding this all the time, trying to get subs and suppliers to sign a unconditional form of waiver in exchange for a check. Just be careful, don't do it. Point out the language at the top of the form that says you're not supposed to do that. It's actually illegal for them to ask you to sign it, but it's happening every day, all the time. So now let's talk about these 4 different forms and the circumstances where you're going to use each one. The conditional waiver and release on progress payment. So when are you going to use this form? Your company is going to continue doing work on this job. This is not your final draw. This is not your final delivery. So that's one of the elements for using this form. The payment has not been received. So this is what you're going to use in exchange for a check. Or you can even sign this one even before you've received a check. Just the promise to pay. Because you're not waiving anything. It's conditional, right? It's conditional. It's specifically, if you read the form, it's specifically conditioned on the payment being received in the future. So if that payment's never received in the future, you haven't waived anything. So you don't have to freak out about signing it before you've received payment. That's why it's conditional, right? Right. Payment, if the payment is by check or ACH, this is the form you want to use. Why? The funds have not been received by your company. That's what you're wanting to use this conditional. So the conditional waiver on progress payment, you're still working on the job, money's not in your bank account. That's when you're using this form. And this is what this conditional waiver looks like. And you'll see that language at the top of this is exactly from the statute. I didn't draft this. This is not any original speech by Rebecca. This is what our Texas legislature put. Seriously, it's my paralegal copied and pasted it onto a slide. There you go. And so you see that first sentence there that says, on receipt by signer of this document of a check from blah, 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 in the sum of blah, 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 payable to blah, blah, blah. That means it's conditional. At the top it says conditional, but the language that makes it conditional is right there, because it's not effective if you never receive the check, or if the check never clears. You never waive anything because of the way it's written. That's why this form is written like that. So that's exactly what you're going to do. So these are what these statutory forms look like. You're going to need to be, you're going to be looking at filling out a few of the blanks on all of these forms. You're going to need to put in, obviously, who's going to make out the check, the amount of the check that you're expecting to receive, or somebody's going to need to fill that out. And then you're going to need to fill in the part that says that you're the statute where you're this position in the construction chain, where you're waiving the project to the following extent. What exactly is this waiver applied to? And that's the part I wanted to call your attention to. The statutory language ends at to the following extent. So how are you going to fill out that part that's after the colon, to the following extent? This is kind of an example of how I'd say you should fill it out, because this is the only part of this form that's a little bit challenging. Is, okay, what do I put right there? My advice is you put just a general description of what's been done, rental equipment furnished by whatever your company name is, or whatever you furnish, electrical work provided by whatever your company name is. And then name the construction project. Yes, is naming that project a little bit duplicative of what you got above naming the project? Sure, but I don't care. Do it anyways. And as described in invoices, put your actual invoice numbers that are being paid. Or if you're doing pay applications, put your pay application numbers that are being paid. That's how you make sure that you're limiting this release. And this applies to all these forms. This is how you make sure you're limiting this release to what's actually being paid, and you're not accidentally waiving more than you want to, right? Right. So now let's move on to our second form, our second Texas legislative form, the unconditional waiver and release of progress payment, the unconditional form of that release on progress payment. So this is the second type of form again. So when are you going to use this? The unconditional form on progress payment. You're going to use this form when your company will continue to supply equipment or material on the job. You're going to continue to do work. Payment has been received. The money is actually in your bank account. No check. The check is already cleared if it was paid by check, but you've got the money in your bank account. So, and you want to make sure this is limited to only the invoices or the pay applications that were actually paid. So that's the caveat, right? Right. So here's, again, this statutory language. This is our statutory form. We just copied and pasted this from the statute. Look at that language in caps at the top. Yes, it's in caps in the statute that says you're not supposed to sign this in exchange for a check. They mean that. That's why it's there. Don't. So this one is not conditional. So if you sign this and you receive a check and the check bounces, you may be out of luck. We're not sure. It hasn't been litigated yet. So please don't be our test case. Here, you're going to fill out the to the following extent portion of this waiver there towards the kind of the middle of that form language right there where you see to the following extent colon. Fill it out the same way, right? What you did, who you are, and which invoices or which pay applications are being paid. A lot of times folks will try to put something in there that's more generic, like a down date, and that's a lot more tricky, right? Because then if you accidentally you figure out that you failed to bill for something prior to that date, or somehow sales didn't let you know that a certain product had been delivered, so the invoice is late, or there was additional work done and you didn't get your change order, but then you've signed a waiver with the down date saying you've been paid for everything before that date. Those down dates get more tricky. So my advice is just don't use a down date. Have it be specific to the invoices or pay applications paid. Now here's our third form from the statute, the conditional waiver release on final payment. So when are you going to use this one? You're going to use this one when you're not going to be doing any further work on this job. You are done. You're not going to be supplying equipment any further. No more materials are going to get delivered. You're done with this job. But you haven't received the final payment. So that's why you're signing a conditional form of waiver, because you haven't received your final payment yet. That is when you're going to be using this form. So here is that conditional waiver on final payment. You'll notice these forms are all pretty similar, but the differences in language is very important. That's why you need to use the correct form for this one. But this is what this waiver will look like. And it's fine to sign this form before you receive that final payment because it's conditional. Look at that first sentence again. On receipt of by the signer of this document of a check from in the sum of, and that's when when the check has been properly endorsed and has been paid by the bank. That's when this becomes effective, not until the money comes into your bank account. So that's why it's fine to sign these conditional waivers even before money has been received. And it's fine to sign a conditional waiver in exchange for a check. It's not fine to sign an unconditional waiver in exchange for a check. So here's our fourth form that the Texas legislature has provided for us, the unconditional waiver and release on final payment. You're going to use this form when you're not going to be doing any further work or providing any further materials to this job. The payment will recover the payment. You've been fully paid. The money's already in your bank account. You've been fully paid, and your company has been paid in full. So that's the only time you're going to use this unconditional waiver and release on final payment. That's what that one's designed for. So here's the statutory form for that form of waiver. It's got that language again in caps at the top that says, hey, don't sign this if you haven't been paid. So don't do that. Now, what if you sign the wrong form of waiver? If, let's say, there's a down date that's wrong, you've signed an unconditional waiver saying that you've been paid through March 31st, 2026, but then you figure out that, oh crap, you really haven't. There was an invoice that got skipped. It really might waive lien rights in Texas. We don't know right now, so just be careful. But it also may create a fraudulent lien argument for the GC owner, because if you go ahead and file, you signed the waiver, the unconditional form of waiver with the down date that was incorrect. You had some money that was owing before that down date. You didn't notice the down date. You signed it anyways. You'd been partially paid but not fully paid. So you go ahead and send your lien notices or file a mechanics lien for the remaining balance that really wasn't paid. It may create a fraudulent lien argument by the owner or GC if you go ahead and file that lien. Now, my practical advice is if you haven't been paid, go ahead and secure your lien rights. I don't care what the waiver says, just go ahead and do it. But you just need to be aware that they may have counterclaims. They may come back and try to fight it, and they may have a basis for that if you signed the wrong form of waiver. Okay. They did in Texas, your lien waivers no longer have to be notarized. That was part of when the legislature tried to make this whole process easier. A lot of GCs and owners are still requiring notarization, and I wouldn't fight them on it because it's so easy to get something notarized. But just technically speaking, lien waivers do not have to be notarized in Texas any longer. So another question I sometimes get is, okay, when I've been paid on a project, how quickly do I have to release, sign the waiver or release? The statute particularly says we're supposed to be doing it within 10 days of receipt of the payment. But now notice my language there, 10 days of receipt of the payment, not receipt of the check. So you're going to need to wait. If you're getting paid by check, you're going to need to allow enough time for that check to clear, or at least for you to be able to confirm it's not going to be returned for insufficient funds. So payment means money in the bank account, not check. But that 10 days. Now, if you don't comply with this 10-day deadline, is that really a super big deal in Texas? No. Folks go over 10 days all the time, and there's no penalty for it. The statute doesn't have any sort of penalty that if you fail to provide the release within 10 days, oh, you're in a lot of trouble and you have to pay a fine, or you're going to be liable to blah blah blah. There's no real penalty for not getting that done within the 10 days, but technically speaking, that's what the statute says. But I see folks going over this 10-day mark every day, and I've only seen it be an issue probably twice in 25 years of practice. So what if the GC or customer sends a different form of lien waiver that they want you to sign? The short answer is, if it's a private project in Texas, that's actually illegal for them to do that. They're not supposed to be using their own manuscript forms, and you're not either. So if you're working on a private project in Texas, you need to be using the statutory forms. Now, if it's state or local government jobs or federal jobs, it's still the Wild Wild West. Can they technically use their own crazy form if it's state or local government work or it's federal government work? Yeah, they can. What's my advice to you? Take their form, throw it away, use the statutory form anyways. If they squawk about that, that's when you have to kind of have a discussion with them about how, what they've asked you to sign really isn't fair for all of the reasons that, we'll talk about. So let's talk about some of the gotcha language in these manuscript forms. If you've got a GC or an owner that's just real dead set on using their form, and it's not a private job in Texas, so let's say it's a state or local government, it's an ISD job, you're working on a school job, and they want to use some crazy form. Let's talk about the language that can be big gotcha language that you're going to be looking for in that kind of a lien release, right? Overbroad language to look for. If the release is releasing any and all claims of every kind, known or unknown, language similar to that. And what that is a broad form release. That is release, and the reason why that language is so dangerous is if you have a problemed project. Let's say there's a death on the job, there's a wrongful death suit by the worker's family, and there's allegations that your product was part of the problem. But your research is that your product wasn't part of the problem, that it was negligence by the GC. If you sign a waiver that has this very broad form of release, rather than just the kind of the narrow language that's releasing your right to payment, your right to a mechanics lien, or your right to payment, which is how the statutory forms read, then you have just waived the right for your company to defend itself, really, against the GC. Because you waived your claim back against the GC that says, you were negligent, it wasn't my product, you were negligent, and so you need to pay this guy. That's the danger of you signing these releases with these broad form waivers in it. So when you're looking for a release, you want it to be a release of your lien rights. That's great. Release of your bond claim rights. That's great. Releasing your right to payment, to seek payment for the invoices that are being paid. Sure, but nothing further, nothing more. You don't want to be releasing any and all claims of every kind. You're looking for that kind of language. Is it going to say that exactly? A lot of times it says something very close to that, but you understand the gist of it. If it looks like you're waiving everything God's creation, that's going to be too broad. My advice is not to sign it with that language in there. What if other language you're looking for states that the claimant agrees to indemnify and hold harmless the owner and GC? Most of the time that language is also very, very broad, and you want to look at it very carefully, or have your legal team look at it very carefully, or just mark it out. If you sign these types of releases, you can be releasing future claims that, for these when these catastrophic issues happen on projects and everyone gets sued, you can be releasing claims that would be very valuable in that type of a situation. So what do you do if they send you one of these broad forms and you don't want to use it? You think, oh, this has some of that language Rebecca said that we shouldn't be using. My advice is honestly pull out that statutory form, one of the ones we talked about just now, the one that's appropriate for your situation, and just fill that in and send it to them instead. And try to approach it that way. Say, hey, this is the statutory form, let's use this. And see if you can get that through. So that is kind of my planned comments, but I'll be happy to answer any questions anyone may have.
Thank you so much, Rebecca. As always, you are incredible and such a source of a wealth of information for us, so I appreciate it. Yes, there are a couple of questions that came through. I think on this, you've already touched upon it, but I'll go ahead and I'll ask it for them. If you are listing the invoices on the waiver, should there be a through date listed on the release as well?
And I honestly don't see the need for it. No.
Okay, perfect. And then it says, should you list exceptions for approved change orders that have not been paid?
Yes, and if you look at that statutory form, it actually has language. It says except for retainage, and then it has a separate blank that says except for. So if you have any carve outs, that's where you put that into the form for sure. So this form actually anticipates if you have carve outs, that's where it goes. The form itself, the form language says unpaid retainage. So you're already going to be protected on your retainage, right? But if you got other things that you just want to make darn sure, and by the way, we probably have this change order that you haven't approved yet, or whatever, that you put it in that. It's in the second paragraph of those statutory forms is where you'll find the blank that's where you put it in. It says except for, and that's where you put in your exceptions.
Okay, perfect. And then there's another question. Is the statement required for the waivers on third month fund trapping notices?
I'm sorry, say that one more time.
Or essentially, are you required to include the statement with the release?
No. You can if you want to.
Okay, perfect. And then another question that came through, it says, most faculty management companies make you sign a service agreement where they say they are not allowed to file liens even if unpaid. Is that legal?
No, it is not in Texas. You cannot preemptively waive lien rights in Texas. That statute and that portion of your contract is unenforceable.
Okay, perfect. Thank you so much for clarifying that. And then another question, it says, on a third month fund trapping notice, there are the conditional and unconditional releases, but on a recorded lien, you have to provide the satisfaction to release the lien. If you accept a credit card payment, once that recorded satisfaction is recorded, it's deemed unconditional. But what if there's a chargeback on the credit card? Is there any recourse to that?
If you've already actually filed a release of your lien of record, you're not going to be able to go back and, I mean, if you happen to still be timely for your lien, could you maybe refile it? Maybe, but it's highly unlikely that would ever happen. That's why I'm saying you are not doing these releases. If there's a chance that that money's not going to hit your bank account or stay in your bank account, just don't do it. Wait. But
right, perfect.
So I don't want you thinking that you have to do, can you use these statutory forms to release a mechanics lien? Yeah, you can. Just fill it out to include the lien. So do you have to do something that's called the satisfaction of whatever? No, you don't. I've never done one of those in my life. We do releases of lien all the time.
Okay. All right, wonderful. That seems to be all the questions that have come through. If anybody does think of another question that wasn't addressed, please feel free to reach out and we'll be sure to answer any questions for you. Can you go to the next slide for us, please?
Sure.
All right, here are some of SunRay's resources to help you stay organized and know your deadlines and secure your lien rights. So please go ahead and scan that QR code to access these incredible resources. Again, this webinar is strictly about Texas lien law. Remember, every state is different. So if you are working in a nearby state and you are not aware of what the rules are or the lien laws are, please check it out because every state requires different document types, different document names, and deadlines associated with that. So make sure that you guys are protected. All right, and then the next slide for me, please. All right, if you don't mind, give us a quick review on Google. We really do appreciate any feedback you're able to provide to us. It takes about a minute of your time, but it helps other contractors like yourself hear about us, as well as it lets us know what you're looking to get information on moving forward. All right, and then the next slide, if you don't mind. And with that, that is all we have for you guys today. Thank you so much to everybody who was able to attend. We hope to see you guys at our next webinar. As always, Rebecca, thanks so much. We really do appreciate you. I hope everyone has a beautiful and wonderful sunny day. Thanks again, everyone.